user.
Good morning. How are you?
Good days.
All right. Do we have any preliminary matters at this time? Okay, sure. If you want to come forward. Okay. Thank you. All right. Good morning, ladies and gentlemen. All right. Have your seat. All right. Your next witness,
We call Dr. Richard Gilbert, Your Honor.
Dr. Gilbert. No.
Please face the court, raise your right hand.
Do you solemnly swear or affirm to testify truthfully in this case under penalty of law?
I do.
Good morning, sir.
Good morning.
Good morning, Dr. Gilbert.
Good morning.
Would you please state your name for the record?
Richard Stephen Gilbert.
And what is your occupation?
I am an orthopedic surgeon and I have a subspecialty training in surgery of the hand and upper extremity.
Dr. Gilbert, where do you work currently?
I currently work in New York and Long Island at Northwell Health.
And you mentioned you have a specialty. Can you tell us a little bit more about what your specialty is?
So after medical school, I trained in orthopedic surgery and I did an orthopedic surgery residency. And for a year thereafter, I did a hand and upper extremity surgery resident fellowship. And so my practice for the past 22 years has been limited to surgery of the hand, wrist, and elbow.
And I think you may have gotten ahead of me there, but how long have you been practicing?
22 years.
Okay. What percentage of your practice over the past 22 years has involved surgery?
Approximately 1/3 of my practice.
Okay. And other than that 1/3 that involves surgery, what does the rest of your practice entail?
The rest of my practice entails some academic work, but mostly seeing patients in the office, seeing them either pre or post-operatively. A large portion of hand surgeons treat patients non-operatively.
In terms of the surgeries that you do, can you describe for us the types of surgeries that you will perform?
So again, I limit my practice to hand, wrist, and elbow. I would say approximately 75% or so of my practice is limited to the hand itself. And this really varies from anything from conditions like carpal tunnel syndrome to tendinitis to injuries such as amputations, fractures, sharp lacerations, etc.
Over the course of your 22 years of practice, how many surgeries would you estimate you've performed?
I perform about 300 to 400 surgeries a year, so a rough estimate would be approximately 10,000, maybe a little less.
Where are you currently licensed?
In New York.
And how long have you been licensed in New York?
I have been licensed in New York since 1994, so that would be 28 years.
And do you have any certifications?
Yes.
And can you tell us about those?
I am board certified by the American Board of Orthopedic Surgery, and I have a certificate of added qualifications in surgery of the hand from the American Society for Surgery of the Hand.
When did you receive your board certification?
2002.
And can you describe for us what current positions you hold?
I am currently an assistant professor of orthopedic surgery at Northwell Health, and I'm also the president-elect of the New York Society for Surgery of the Hand.
In what professional organizations are you a member?
I'm a member of multiple orthopedic organizations, including the American Board of Orthopedic Surgery, the American Association of Orthopedic Surgery, and the American Society for Surgery of the Hand, as well as the New York Society for Surgery of the Hand.
Have you published any articles in your field?
Yes, I have.
Have you testified as an expert before?
Yes, I have.
Can you ballpark for us how many times?
Certainly less than 10 over the past 22 years.
Your Honor, at this time, we'd like to offer Dr. Gilbert as an expert in the field of orthopedic surgery, specializing in the hand.
All right, any objection?
No objection, Your Honor.
So moved.
So, Dr. Gilbert, what work were you asked to do in connection with this case?
So I was asked to review medical records, radiographs, pictures, as well as testimonies and depositions related to Mr. Depp's finger injury.
Okay. And to your understanding, what is Mr. Depp's explanation of how his finger was injured?
He describes that he was in Australia and his right hand was over the side of a bar when a vodka bottle was thrown at his hand, injuring his right middle finger. And he describes that the vodka bottle exploded.
Are you aware of other explanations for that injury?
There have been multiple other explanations, but I think the one that was brought out was by Ms. Hurd, who believed that Mr. Depp was holding a landline and out of anger was punching it against the wall, and this resulted in his right middle finger injury.
Okay. Based on your review of the medical records and other documents in connection with Mr. Depp's finger injury, how would you describe the nature of the injury to Mr. Depp's finger?
Well, the nature of the injury was he had what we describe as a comminuted fracture of the distal phalanx, meaning there was a fracture of the tip of the finger, and comminuted meaning that there were multiple pieces. So this is some type of blunt force with a high mechanism of injury. He also sustained loss of the tissue along what's called the ulnar side of the finger towards the little finger. And this appeared, based upon my review of the pictures, to be some type of sharp laceration because it represented a clean edges of the wound.
Can we take a look at Plaintiff's Exhibit 60? And pull up to go to page 3. And Dr. Gilbert, are you familiar with this document?
Yes.
And what is it?
So these are two radiographs, x-rays of Mr. Depp's finger, his middle finger.
Okay. Sorry, just to stop you, but Your Honor, may we publish this to the jury as a demonstrative?
Any objection?
No objection.
All right, we'll identify it as 60, page 3, and publish to the jury.
And Dr. Gilbert, sorry to cut you off
that's
there. Can you just tell the jury what we're looking at here in this
We're looking
X-ray?
at two x-rays of Mr. Depp's right middle finger after the injury, and towards the tip of the finger there's a fracture, again what I described as a comminuted fracture, meaning there are multiple pieces at the tip. There's also a transverse component to the fracture closer to the joint.
In your view, what types of mechanisms can cause this sort of injury?
So this is a mechanism of injury that has high velocity or force, generally a crush type. Fall would not result in such as is seen in these x-rays.
And we're using the term comminuted fracture. Can we just define that quickly for us?
So again, comminuted, and it's not particular to a finger, is a medical term for a fracture that has multiple fragments.
In your opinion, could this injury have been sustained in the manner Mr. Depp described?
I do believe so.
And how might that work? How might a thrown vodka bottle produce an injury like this?
So a vodka bottle, which is a hard object, would have crushed the tip of the finger, resulting in the comminuted fracture. And in addition, as the vodka bottle broke, the glass would have lacerated the finger, resulting in the soft tissue loss that was also seen with this injury.
What's your assessment of the description of the cause of the injury offered by Ms. Hurd?
I think that's highly unlikely.
And why is that?
Because in general, when an injury is caused by punching against a wall or a hard object, it is extremely rare to see an injury to the tips of the fingers, which is seen with Mr. Depp's injury. Generally, you're holding something with a fist, and that in general leads to injuries most commonly of the knuckles here, or fractures of the metacarpals. We call these boxer fractures. Second most common after those would be injuries to these, but as you can see, if you're holding something and hitting against something, it is very unlikely that the tips of the fingers will be injured. In addition, just taking into account the radiographs and the pictures of the injury, I would not believe that a blunt force, solely a blunt force against a wall would result in the soft tissue loss.
What other injuries, if any, would you expect to see on Mr. Depp's hand if the injury had occurred as Ms. Hurd described?
So if you would have, if that were the cause of the injury, you would certainly, that would be a dorsally directed, so this is the dorsal in the back of the hand as opposed to the palmar side. So if you're punching against something, you would certainly expect an injury to the nail bed, and those are always seen in those type of injuries. If there is an injury to the tip of the finger, which again I said is rare. So you would see either a loss of the nail or blood underneath the nail called a subungual hematoma.
In your review of the medical records, did you see any sign of anything like that?
None whatsoever.
In your view, is the injury, can you explain to us exactly why you think the injury is consistent with Mr. Depp's description?
Well, again, his hand, he describes his hand being held over a marble bar, which is a firm, something firm, unyielding, and the bottle hit against the finger. So basically the finger was crushed, resulting in, again, what I described as a comminuted fracture. And as Mr. Depp described, the bottle exploded, so it's certainly reasonable that the glass that exploded as well led to the soft tissue loss along the ulnar aspect of his finger.
Okay. Now, did you observe the testimony of Dr. Richard Moore?
Yes, I did.
And he testified about Mr. Depp's finger injury as well?
Correct.
Right. Did you agree with Dr. Moore's testimony?
Certain parts of his testimony I did, yes,
Okay.
but not all of it.
Focusing on the parts that well, first of all, why don't you tell us what you agree on?
Well, I agreed in terms of his interpretation of the x-rays, saying that he had a comminuted fracture and this was some type of high force injury.
Okay. What did you disagree with?
Well, I disagreed with several things that he said. He first said that he does not believe that the mechanism of injury could be, as described by Mr. Depp, holding the hand on the side of a marble bar, because he said it was all a palmar injury, and there was a palmar component to the injury. I'm talking about the soft tissue loss, but there was also a dorsal, meaning the back of the finger. So the soft tissue loss was actually, if you looked at the pictures which were shown when Dr. Moore testified, the injury goes like this. So it's an angled or an oblique type injury. And there's no way that anybody could determine whether or not it was a palmar directive force, meaning from the palm side, or a dorsally directive force. But certainly either are plausible.
Okay. Anything else come to mind that you disagreed with?
Well, he also described that this was definite. Well, he thought that this was a pinching, or what he described as an avulsion type injury, and that's referring to the soft tissue loss. That's certainly possible, but if you look at the pictures that were shown when he testified, the laceration looked fairly clean. There were clean edges. It was not jagged. And generally, when you have an avulsion or a pinch type injury, you see a very irregular border to the skin. It's pinched off, you can imagine, as opposed to something that's cleaner that would be lacerated by, let's just say, a piece of glass or a knife or whatever. And that's more consistent with the pictures of Mr. Depp's injury.
And we're using the term soft tissue loss, and just to make sure we're on the same page, can you just tell very quickly what you're referring to there?
Right, so there were two components to this injury. One, the fracture of the bone, and two, he had loss of the soft tissues so that the bone was exposed. So that amputated part that was found at the bar.
Now, you were saying that Dr. Moore testified that this was an avulsion, and meaning a pinching injury, right?
Correct.
Why do you believe it's more likely that it was a laceration?
Well, again, in general, a pinch-type injury results in, one, much more damage to the remaining tissue, but the remaining tissue is usually very irregular. The borders are jagged, and that's not what was depicted in the pictures.
Dr. Moore also testified that he thought a vodka bottle might not have sufficient force to cause the injury here. Is that your understanding of his testimony?
Correct.
What's your response to that?
I certainly believe that a vodka bottle that was thrown from a distance against a hand that was resting on a marble bar is more than sufficient force to result in this fracture and soft tissue loss.
Now, in looking at the medical records and the pictures of Mr. Depp's hand, what was the condition of his nail?
There was no injury to the nail.
And other than what you've already told us, how does that factor into your analysis, if at all, the fact that there was no injury to the nail?
Well, it makes it highly unlikely that the mechanism of injury described by Ms. Heard resulted in this injury, because you really would always see an injury to the nail and or nail bed.
Do you have any opinion regarding the direction of the injury?
Well, it's certainly based upon the soft tissue loss. It's an angled injury, or what we call medically an oblique injury, because the soft tissue loss is at an angle. He lost some of the tissue on the back of the finger as well as the palm side, primarily along the palm side. But other than that, you can't make any assumptions. Unless you saw a videotape of this injury, nobody could tell you definitively what the direction of the injury was.
Dr. Moore also commented on the absence of fragments of broken glass in Mr. Depp's injury. Do you remember that?
Yes, I do.
And how does the absence of glass fragments factor into your analysis?
It really doesn't. I've seen hundreds, if not probably at least 500 or more glass injuries, and I would say probably the majority you don't see glass in these injuries. It is much more common to see glass embedded in the wounds when you're talking about very fine glass. So if, just say, a wine glass would explode or something of that nature, where you get little tiny shards. But in general, when you have thick glass, such as you see in a bottle or a pane of glass, you generally don't see, because they break into bigger pieces, and you generally don't see the glass. But you certainly can, but it's not surprising that you don't.
Can you definitively state how this injury occurred?
No, nobody can definitively state.
I have no further questions, Your Honor.
All right, cross-examination.
Thank you, Your Honor. Good morning, Dr. Gilbert.
Good morning.
Now, you're being paid $1,000 an hour for your work on this case, correct?
Correct.
And you agree, just to sum up how Mr. Moniz finished, you agree that the finger injury could have been caused by any number of things, right?
Yes.
And you're not offering an expert opinion on what you believe caused the finger injury, correct?
Correct.
And you're aware, you said a few times Ms. Heard's account or Ms. Heard's explanation, right? You remember saying that?
Yes.
You're actually aware that Amber has said she doesn't know how he lost his finger. You're aware of that, right?
Yes.
So when you were just talking about Ms. Heard's account or Ms. Heard's explanation, you're aware she's never actually given an explanation for how she thinks he lost his finger, correct?
No.
Yeah. You're aware that Ms. Heard testified, and this was from your deposition, you're aware that she testified she doesn't know how he got his fingertip chopped off. You're aware of that, right?
Asked and answered, Your Honor.
Overruled.
No, I'm not. I reviewed the records, and in one of the testimonies depositions that I reviewed, it was described that that potentially it was lost when he was punching against the wall with a phone.
And on that, the last point there, I think we agree. Ms. Hertz testified in this trial and previously that she saw him smash a phone to smithereens, a wall phone. You'd agree with that, correct?
Correct.
But she doesn't know if that was what caused him to lose his finger. You agree with that, correct?
I agree. I cannot speak for her, but yes.
Okay. May I approach, Your Honor?
Yes, sir. Thank you.
Dr. Gilbert, you gave a deposition in this case on March 17th, correct?
Correct.
You were under oath in that deposition. You swore to tell the
Correct.
truth, correct?
Correct.
Okay, if you could turn to page 61, please. You see there are four pages per page of paper. It's on page 16 of the document.
Okay.
Okay, in line 9, you're asked a question, and then Amber's response to that question, that's the line 9. Can you read that, please? Answer, I do not know. I did not see his finger go off. Question, and Dr. Gilbert, are you aware that Amber did not see Mr. Depp's finger go off? Answer, I mean, I'm aware that, well, I am from reading this. I'm aware of the mechanism that she claimed would cause the finger injury. Question, but have you read anything so far that indicates she doesn't know how the finger injury happened? Answer, so far from what I'm reading here, yes. Did I read that right?
Yes.
And you've heard no testimony in this trial from Ms. Hurd that the finger injury was definitively caused by the phone, so that she doesn't know, correct?
Correct.
And you'd agree that the fingernail was uninjured. You said that, right?
Correct.
And the nail bed was uninjured.
Correct.
Correct. But the area under the fingernail, in the pulp of the finger, that's where the injury took place, right?
It was not isolated to the pulp, no.
But it didn't injure the fingernail. That's my question.
Correct.
Okay.
Yes.
And under Mr. Depp's alleged theory, Amber threw a vodka bottle at him from 10 feet away or so, right?
Correct.
And you testified you have no way to determine the angle that the bottle was coming from.
Correct.
Right? But she threw it on a downward trajectory, correct? She didn't. There's no allegation. You've never read anything that she somehow underhanded it so it came up to his finger, right?
Correct.
And there's no way to tell, as you testified, what exact direction it came from, right?
Correct.
And the glass exploded, but you've already testified there was no glass in the wound, right?
Correct.
You haven't read any record of that in any medical records, correct?
Correct.
You also haven't read anything about there being cuts on the rest of his hand, right?
Correct.
And there was no glass found anywhere on the rest of his hand, correct?
Correct.
No bruising or injury on any other part of his hand other than the tip of his middle finger.
Correct.
And somehow, under Mr. Depp's theory, that bottle hit the bar and his fingers, but didn't damage the fingernail while it amputated the area under the nail, correct?
Correct.
And your explanation of that is that you believe that his hand must have moved at some point during the force of the injury. Isn't that correct?
No, I said it could have, but I did not say that it did.
No, you believe that it did, don't you?
I said that it likely did, but I was not there, and I don't have videotape of the injury, so I can't determine that definitively.
Okay. Well, let's turn to page 25 of your deposition, please, on page 7.
Sorry,
Page 25 and 26, so it's page 7 of the document.
Okay.
Sorry if I was unclear on that.
No problem. I'm there.
Okay. Line 18, question, and to be clear, by, quote, sitting in that position, you mean hand down, palmar side down. Answer, that's what he claimed. I mean, according to the history, yes. Question, and would it matter if Mr. Depp's hand was palmar side down? Answer, not really, because it really, and I discussed this, it really just depends upon the angle at which the injury occurred, and as well, you can't determine if his hand had moved at some point during the force of the injury, which I believe it probably did, which I didn't get into in my note here, but question, and why do you believe that? have you read anything in any of the materials to suggest that? Answer, no. Just that if it completely hit on the back of the finger, then he would have had a nail bed injury, which he did not. Did I read that right?
Correct.
That was testimony you gave under oath a month or two ago, right?
Correct.
So even though you have never read anything that suggests Mr. Depp's hand moved, his hand moving is the only way that you can fit your testimony into what Mr. Depp wants you to testify to about how the injury occurred, isn't it?
No, that's incorrect.
Okay, that's what you testified to, that if his hand hadn't moved, that there would be a nail bed injury, correct?
That is incorrect. That's not what I testified. That's
In
not
fact,
what,
Dr. Gilbert, there's another explanation for how Mr. Depp somehow suffered an injury that didn't injure his nail one bit, but injured underneath the nail. And that explanation is that it didn't happen how Mr. Depp says it did, correct?
I cannot make that assumption, nor can you.
No further questions.
All
Thank you.
right, redirect.
Dr. Gilbert, just very briefly, the absence of other cuts on Mr. Depp's hand, how do you factor that into your analysis?
You certainly can see an isolated finger injury with any type of injury, and I would say any other host of mechanisms of injuries, you'd more likely see other. So again, if you're, I'm just using this as an example, if you're punching against a wall, you would more likely see multiple injuries to multiple fingers. It really just depends upon how the bottle or how the mechanism of the injury impacted the hand at that point in time.
Ms. Heard's counsel made a point of emphasizing that there were no bruises or other injuries on the hand, right?
Correct.
And how does that fact affect your analysis, if at all?
Well, it doesn't discount anything, but it certainly makes other potential causes of injury more unlikely, meaning punching against a wall or getting the hand slammed in a door or something like that.
And your discussion of Ms. Heard's explanation of the alternative cause of the injury, was that based on anything other than Ms. Heard's statements?
No.
No further questions, Your Honor.
All right, thank you. Doctor, you can have a seat in the courtroom or you're free to go. Thank you. You can just leave it there. That's fine. Thank you, sir.
Thank you.
All right. Your next witness.
Plaintiff rests, Your Honor.
All right. Plaintiff rests the rebuttal case. All right. Defendant counter plaintiff rebuttal case. Sure. All right, rebuttal evidence.
Yes, Your Honor.
Mr. Murphy?
We call Mr. Julian Ackert.
All right. Mr. Ackert? He has to be sworn.
Do you solemnly swear or affirm to testify truthfully in this case for penalty of law?
Good morning.
Morning.
Can you please state your name?
Julian Ackert.
And can you please describe your educational background following high school?
I have a Bachelor of Science in Computer Science from the University of Virginia.
What is your profession?
I am a computer forensics investigator.
Where are you employed?
I work for a company called iDiscovery Solutions, or IDS.
And what is your title?
I'm a managing director at that company.
What services does IDS perform?
IDS provides consulting, expert testimony, forensic analysis, data analysis, electronic data review and production services, all to the business and legal community.
What, if any, of those services performed by IDS have you performed?
I perform all of those services.
How many years of experience do you have in computer forensics investigation?
I've worked in the industry for 20 years.
Can you please describe that experience to the jury?
I have experience creating and implementing data preservation and collection strategies, doing data collections in a forensically sound manner, extracting data from collections, as well as analysis and metadata analysis of the evidence that I extract.
You mentioned collecting data from forensic collections. What material are you forensically imaging?
This would be any type of material that stores digital evidence, an iPhone, an iPad, a tablet, laptop, a cloud account, your Gmail account, anything that has digital evidence.
Have you published in your areas of expertise?
Yes, I've published on data preservation and collection and analysis strategies.
Have you ever given any trainings or presentations to other individuals in the e-discovery area?
Yes, I have. I do trainings and presentations to lawyers through continuous learning education.
What, if any, professional certifications do you have?
I have a GIAC GCFE, that's the GIAC Certified Forensic Examiner certification.
And what were the requirements of obtaining that certification?
To obtain that certification, you need a minimum number of hours in the field, as well as you need to pass a test with a certain degree of, a certain percentage of passing.
Do you belong to any professional organizations?
I do. I'm a member of a conference called the Sedona Conference. It's a conference that is a group of legal professionals, judges, and technologists, and we discuss the intersection of law and technology issues in the legal community.
Have you previously served as an expert witness?
Yes, I have.
And when did you first serve as an expert witness?
I believe that would have been around 2009 was the first time I served.
Have you previously been qualified as an expert witness in the field of computer forensics?
Yes, I have. I've been qualified probably a half dozen to a dozen times in both federal and state court, including this court right here.
And has a court ever declined to qualify you as an expert witness?
No, they have not.
Your Honor, I offer Julian Ackert as an expert in the field of computer forensics.
No objection, Your Honor.
All right, so moved. Could you just spell your last name for me, Mr. Ackert?
Ackert, Ackert.
Thank you so much, sir.
Mr. Ackert, what is forensic imaging?
Forensic imaging is the process of capturing the data on a digital device in a forensically sound manner.
And how is a forensic copy created?
Using specialized software that's available to forensic investigators, we're able to collect the data from devices, and that software may vary depending on the device, like a phone or a laptop.
What type of information does a forensic image collect?
It's meant to really collect everything on the device. So for example, on a laptop, it's going to collect your documents, your emails, your photographs, your documents like Excel spreadsheets, PDF files, any applications that you ran, the history of what you've opened or looked at on the laptop, as well as all of the metadata for these different types of electronically stored information files.
And does any other information accompany that information that's collected?
Typically with a forensic image, you're also going to get log files. Log files are files that help you validate the forensic image and verify that it was a forensically sound data collection.
And how do log files enable you to do that?
Log files list information within the files. Sometimes they're even embedded within the images themselves, but they provide verification information that allows you to authenticate the image and the data on the image.
What is the purpose of creating a forensic image of devices or data?
In order to extract and analyze data forensically for the courts, you need to create a forensic image of the data first and gather the data from the forensic image.
And what, if any, specific types of data are collected in that image and extraction?
It's going to be any type of data that comes from the image, whether you're extracting photographs or documents or spreadsheets or anything of that nature.
Do you recall Mr. Neumeister mentioning the term hashing yesterday?
I do.
What is that?
Hashing is essentially a digital fingerprint of a file. It's an evaluation of the binary ones and zeros, or how the file is stored on a hard drive, and it examines the ones and zeros in a manner that gives every file a digital fingerprint, essentially, and identifies the uniqueness of the file.
And what, if any, applicability does hashing have to the visual appearance of data?
Hashing has nothing to do with the visual appearance. For example, if I had a Word document that I printed and then saved, therefore I haven't visually changed the Word document, the metadata of that Word document indicating that I printed it would be different, and therefore that Word document would not hash to the version that I used before printing.
Can you give any examples of digital photographs that visually appear the same, not hashing?
I believe Mr. Neumeister included 3 of those in his demonstratives yesterday, 3 side-by-side photographs that looked visually the same but did not hash. It made sense that they wouldn't hash. Each of them had different file sizes. And a file size can change for a photograph depending on what you do with the photograph. So for example, maybe you want to take that photograph and email it to somebody, and on your phone, you choose to use a small, medium, or large, or different size of the photograph when you email. When you send that email with that photograph, you've changed the hash value because you've changed the ones and zeros because you've changed the size of the photograph.
And what, if anything, do you recall from Mr. Neumeister's testimony regarding Photos 3?
Mr. Neumeister was concerned about a particular metadata field, EXIF metadata, which there's 2 types of metadata for files. There's the embedded metadata, which is what we're discussing here, the EXIF metadata, and external metadata. And Mr. Neumeister was concerned with embedded metadata within the file that indicated that the software version that the file last ran through was Photos.
What is Photos 3.0?
Photos is actually the software application that's built into the Apple Macintosh operating system for laptops. This is the application that launches by default when you're on an Apple computer and use Photos.
What are the capabilities of Photos 3.0?
There's multiple capabilities for it. You can, for example, create an album with it and put multiple photos within an album. You can organize or sort your photos by date and time taken or place. You can also use that to edit photos.
You mentioned metadata earlier. What is that?
Metadata is information about a file. For example, with a document, it could be when was the document created or last saved, or who saved it, who was the author of the document. For photographs, metadata includes information that you've seen on demonstratives before, including when was the image taken, what kind of phone took the image, what software was originally used for that image. Any type of information inside the photograph, the EXIF data that you've heard, is metadata.
Did you form any opinions in response to Mr. Neumeister's testimony regarding Photos 3.0 appearing in a software EXIF metadata field?
Yes, I did.
And what are those?
My opinion is that for each of the photos that he identified, for all but one in his demonstrative, I actually found the equivalent original photo that did not have photos in the EXIF metadata. In other words, those are the photos that he was indicated he would have expected to see the iOS or the phone software version on those photos.
How do you know it is an original version of the photograph?
This is a little bit dependent on the Apple ecosystem. Amber uses Apple devices, and those devices, by definition of how Apple works, synchronize your information from device to device. So for example, if you take a photo on your phone, you see that same photo on your tablet or your iPad or your iCloud account or even your MacBook. And that's all because of user experience. Apple wants you to be able to see and visually have the same experience on all your devices. So the photo that was originally taken traverses or gets synchronized to other devices by design of Apple, and that synchronization process does not affect the metadata that we're talking about here, which is the embedded metadata.
When you say that a version of iOS software was listed in the software EXIF metadata field, what does that mean?
That means that the photo was not saved using the Photos application.
And what, if any, data sets did you use to come to that conclusion?
I used all of the data sets that I collected or were collected for Amber, including mobile devices, tablets, laptops, etc.
Michelle, can you please pull up Defendant's Exhibit 1671? Do you recognize this chart, Mr. Eckert?
I do.
What is it? Without yet saying what the contents, just generally, what is it?
This is a chart I created as part of my report.
Your Honor, permission to publish Defendant 671 is a demonstrative.
Any objection?
No objection, Your Honor.
All right. It'll be published as a demonstrative.
Mr. Acker, can you please describe in more detail what the information in this chart is? And Michelle, if you could just stay at the top for a quick second. A little further up. Great.
Thank you. This chart represents for each of the items in Neumeister's report, which his demonstrative was based on, the page number of the item on his report and the items that I found on Ms. Hurd's devices that did not indicate the software metadata field showing photos. Rather, they indicated that they were the original software metadata field of iOS.
And do you see the second column titled Neumeister Report Date Captured?
Yes, I do.
What does the information in that column mean?
This is the date time metadata of the particular photo on Neumeister's report. So for example, the first row, 23, the date time captured, or the date captured is December 16th, 2015. The second row, 24, you see that the date time is May 21st, 2016. Third row, May 21st, 2016. Fourth row, May 21st, 2016.
Can you just scroll to the next page, please, Michelle? Please continue for the items on this page.
The top row of this page, the one that came from Neumeister's report, page 30, shows December 16th, 2016. And then finally, 32 shows March 23rd, 2013.
Do you see, can you scroll back to the top, please, Michelle? Do you see the, all the way to the top, I'm sorry, the right-hand column of this chart?
Yes, I do.
And where it says device ID and file name?
Yes.
Can you please explain what the information in that column means for each of the items identified from Mr. Neumeister's demonstrative?
So these are the evidence IDs, and evidence ID is the ID value I give to a particular piece of data that I collect, for example, a phone or a laptop, and the matching file name found on that evidence ID that indicated the original version of this same photograph that Neumeister identified that did not show photos in the software metadata and rather showed the iOS version in the metadata.
And what do the little A's followed by numbers back up, what does that mean?
Those are evidence IDs. Anything with an A number is the evidence ID of an actual device collected. Anything that starts with a backup and follows by another number is an iTunes backup.
So what, if any, what items in this right-hand column, based on the coding you have here, are iTunes backups?
Only the ones that start with the word backup. Even the ones that start with an A number are actually an iTunes or an iOS backup in iCloud. So your phone can actually be backed up to iCloud, and those are coming from an iOS backup in iCloud. Everything else is coming from an actual physical device.
Can you just take this down for a second, Michelle, and pull up 1675, please? Defendant 1675. And do you recognize this chart, Mr. Eckert?
Yes, I do.
Without yet getting into the contents, can you please describe generally what it is?
This is a chart that I prepared as a summary of my findings.
Permission to publish defendant 1675 is a demonstrative, Your Honor.
Any objection?
No objection.
All right, 1675 will be published as demonstrative.
Can you please describe in more detail what the 3 columns you can see in this chart represent?
Sure, this starts to give some detail about the particular evidence ID. So for example, A001 was an iPhone X of Amber's that was collected. A002 was an iPad of Amber's collected. A11, 12, and 13, slightly down, are 3 different laptops that were collected for Amber.
And do you see the IDS evidence number column?
Yes, I do.
Do you see the source type column
Yes, I do.
and the source details column?
Yes, I do.
Can you please describe what those columns mean?
Generally, the IDS evidence number is the evidence number that we assign to a particular piece of evidence, and the type and details come from a description of that type of evidence based upon the collection set.
And Michelle, can you please do a side-by-side of 1675 and 1671? Thank you. So, Mr. Acker, can you please describe the relationship between these 2 demonstrative exhibits?
Certainly. If you look at 1671, the one on the left, you can see in the 4th column the different evidence IDs where I identified the original versions of those same pictures that Mr. Neumeister had specifically identified and the sources of where they were identified. So if you look at the first one, for example, the picture Neumeister referenced on page 24, or I guess that's the second one, there are equivalent versions or original versions of those that do not show the software EXIF metadata field of photos. Rather, it shows the original iOS version on A001, which was Amber Heard's iPhone X, A002, which is Amber Heard's iPad Pro. Scrolling on down through there, you see it on A0011, which is Amber Heard's laptop, same with A0012 and 13. You can see this again with the next row that's visible at the very top. Neumeister identified a photograph on page 30 taken on December 16th, 2015, and he was concerned about the EXIF metadata of that, showing the software version of photos. The original versions of those were found again on A001, that's her iPhone X, A002, her iPad, and it's not surprising to me that I found all these on all the devices because that's how the Apple ecosystem works. It replicates your pictures or synchronizes your pictures across your devices when you take them.
Mr. Acker, you can take this down, Michelle. Do you recall Mr. Neumeister's testimony regarding what he claims of EXIF metadata modification?
Yes, I do. This is a completely hypothetical scenario. Mr. Neumeister never specified any pictures with specificity that had EXIF metadata modification, and it's a hypothetical in my opinion.
Mr. Acker, did you form any overall conclusions in this case?
Yes, I did.
And what were those?
The images that were created in this case included log files that allowed me to validate and verify the evidence collected. I validated and verified the log files of the evidence for which I found Mr. Neumeister's original photos that he had concerns about, specifically the ones that had iOS in the software metadata field. I validated that those came from devices that had log files that were validated by me. In other words, they came from original evidence files, and in most instances, they came from more than one file.
Mr. Acker, the opinions you have testified to today made to a reasonable degree of forensic certainty.
Yes, they are.
No further questions, Your Honor.
All right. Cross-examination, sir.
Thank you, Your Honor. Good morning, sir.
Good morning.
You've worked with opposing counsel's law firm approximately 20 times before?
Give or take, yes.
For more than a dozen years?
Those 20 probably would have been spread out over more than a dozen years.
Okay. As you sit here today, you cannot testify that all of the photographs produced by Ms. Heard are authentic originals, correct?
No, I can testify to the ones that Mr. Neumeister identified with specificity.
Right, but there were thousands of photographs provided that Mr. Neumeier didn't testify about, right?
I have no opinions on any photographs that the opposing expert has no opinions on.
All right. My question to you, though, is as you sit here today, can you testify that all the photographs produced by Ms. Heard are authentic originals?
As I sit here today, I cannot opine to photographs that have not been presented to me that are not authentic originals.
All right. You'll agree with me that in some instances, Ms. Heard produced multiple versions of the same photograph, right?
Yes.
Yeah, you just talked about it, right?
Yes.
All right. And you'll agree with me that the XF data of some of the photos produced by Ms. Heard reflect the use of a photo editing application.
No.
No?
I'll agree that they show the use of the Photos application, which is a sorting and editing application.
Okay, so what you were quibbling with is that it will both sort and edit.
That is correct.
Okay. Are you prepared to swear under oath that each and every photograph provided by Ms. Heard and entered into evidence in this court is an authentic original?
Based on the metadata that I have reviewed of the specific photographs I have reviewed, I can confirm that those are authentic original photographs. For the ones that Mr. Neumeister identified, I identified photos that were authentic originals.
No, I'm asking you a broader question than that. There were multiple photographs that Ms. Heard provided that were entered into evidence in this court. Are you testifying that those are each authentic originals?
I have no testimony or opinion on those because nobody's provided me opinion that they're not.
Okay. Mr. Gibson, will you pull up Defendant's Exhibit 712 and Defendant's 713 next to one another? Your Honor, these have already been admitted, and I ask that we publish it to the jury.
Okay, if they're admitted, we can publish.
Can you see this, sir?
Yes, I can.
You'll agree with me that those are different pictures?
Visually, they look different to me, yes.
All right. We can take that down. Mr. Gibson, can you pull up Plaintiff's Exhibit 1308? This has not been admitted, Your Honor, and I propose to use it as a demonstrative.
Any objection?
Not as a demonstrative, Your Honor.
All right. Be identified and published to the jury as a demonstrative.
Any objection to entering it into evidence?
I would object it's cumulative, Your Honor. Actually, no. No objection, Your Honor.
No objection. All right, it's in evidence then.
All right. 1308 is in evidence. Mr. Gibson, can you blow up the time, date, and file name? Sir, you just agreed with me that those two photos are different photos, correct?
I agreed that they were visually different, yes.
Right. So they are two visually different photos that were created at the exact same hour, the exact same minute, the exact same second as each other, correct?
And that's what the daytime metadata shows, yes.
And the metadata shows something else too. They have the exact same file name, don't they, sir?
Yes, but that's not embedded metadata.
Right. How would you have this jury decide which one is real?
I think you would need to look at the software metadata field, which I haven't looked at. I don't recall if I looked at for this particular field, but I think that's what even Mr. Neumeister said, that you need to look at the software metadata field.
But we have two photographs entered into evidence in this court that have the same identifying information, but in your view, look visually different, correct?
I don't agree that they have the same identifying information. I don't see a software metadata field here.
The identifying information includes the hour, minute, and second they were taken, this picture were taken.
I see that.
No further questions.
All right, and just for the record, since we already have 712 and 713 in evidence as redacted, now this will be 712 and 713A. So 712A and 71213A are now in evidence, just to keep the record clean, okay? All right.
Thank you, Your Honor.
Redirect.
Mr. Acker, you just mentioned embedded metadata. What is that?
Embedded metadata is metadata inside a file. I talked earlier about the date printed of a Word document. That's embedded into the file, and that traverses with the file wherever it goes.
And based on all of the photo metadata you have reviewed, do you have any reason to question the forensic authenticity of any photos Mr. Neumeister testified to for which you were responding to?
Can you repeat that question, please?
Yes. Based on all of the photo metadata you have reviewed, based on the photos Mr. Neumeister testified to, do you have any reason to question the forensic authenticity of those photos?
I do not.
Following your cross-examination, Mr. Acker, have any of your opinions in this matter changed?
They have not.
And is it still your testimony that the opinions you testified to do today are made with a reasonable degree of forensic certainty?
Yes.
No further questions, Your
All
Honor.
right, thank you. Sir, you can have a seat in the courtroom or you're free to go. All right. Did you want to approach just for a moment? All right, your next witness.
Your Honor, we would like to call Dr. Don Hughes to the
All
stand
right,
again.
Dr. Hughes. Thank you, Doctor. Just a reminder that you're still under oath, okay, ma'am?
Yes, Your Honor.
Thank you.
And could you please just remind the jury who you are again?
Sure, I'm a clinical and forensic psychologist. I am board certified in forensic psychology. I am the president-elect of the trauma division of the American Psychological Association. And I evaluated Amber Heard over 6 visits for approximately 29 hours.
Okay. And why are you here today?
To offer rebuttal testimony to Shannon Curry's testimony of yesterday.
Okay. Now, Dr. Curry said you used improper methods. Would you agree with that?
No, I would not.
Why? Please explain.
As I testified to you all several weeks ago, I used a standard forensic procedure that is well established in our field. It is a multi-method, multi-hypothesis-driven procedure where you're looking at a variety of different details and tests and external data to arrive at an opinion, and you're looking at the consistency across that data. There are three sort of sets of tests that we use as forensic psychologists, and I think that's where it seems that Dr. Curry seems confused. We have forensic assessment instruments. Those are instruments that are very neatly tied to a legal criteria. Those are most notably done in a criminal court for competency. If someone has competency to stand trial, we have very clear measures that can track that legal criteria. The next level are forensically relevant instruments. And those instruments are not linked to a specific legal criteria, but they do have information that's germane to that finding. And that can be an example of a risk assessment measure and a malingering measure. So the malingering measure that I utilized was the MFAST, and that was the only malingering measure in this case. The third category are clinical assessment instruments, and those are instruments that are validated and well-researched and used in the clinical realm as we understand people's symptomatology and diagnostic and functional capacities. Those are things like the MMPI, the PAI, the CAPS, the TSI, because they are clinically relevant and they still give us very valuable information to individuals who are involved in a court case. And the reason that we do that and we use these clinical measures is because the majority of the people that we see are in a clinical realm. They're not in a courtroom. So they're well-validated and well-researched methods. What we also do is use a very different types of tests within that category. We use some checklists, some face-valid checklists. We use some tests that are those broadband personality inventories. We use structured clinical interviews. And then we look for the consistency across those data points. And when we use different types of tests, it gives us information about the individual, how they go about these tests in these different modalities.
Now, Dr. Curry seemed to suggest that Amber Heard tested the most extreme category in all of these different tests. Is that accurate?
Objection compound.
Overruled.
That is not accurate. They were not on the checklist. I mean, people sometimes do. They go, all the time, this happens to me all the time, frequently. And that is not how she endorsed these tests. She endorsed them in a very moderate way, in a very nuanced way, describing her symptoms that I determined was accurate and reliable.
Now, Dr. Curry also suggested that Amber Heard was tested very, very high, 98th percentile, I think, on malingering and feigning. Could you speak to that, please?
Sure. So, I mean, she said a lot of things, so let's go through those tests. The first was the PAI, and that's that other broadband psychological
Objection
measure.
non-responsive.
I think it's very responsive.
Sustained.
Okay. Could you tell the jury about the PAI test that Dr. Curry addressed?
Yes. Thank you. So that's the broadband measure that has validity scales built into it that gives us indications about how the individual goes about the test. I told you last time that there was no evidence of malingering or exaggeration or feigning on that test. What Dr. Curry was talking about was this tendency to put your best foot forward to minimize faults on this PAI. That scale was right at the cusp. And then there are two other measures that we look at that to say, you know, is this enough for an elevation for me to consider that as a serious response distortion, of which Dr. Curry was saying, and it was not. What was relevant on this test was there were elevations on anxiety, on affective anxiety, meaning anxiety, tension, worry, on traumatic stress, on hyperactivity, and on affective instability. Those were the four scales that were elevated on this test. The borderline scale was not elevated on this test. And this test...
Objection, Your Honor. May we approach?
Yes.
So Dr. Curry, let's move to the TSI-2. Dr. Curry testified about your findings on that. Did you agree with her testimony yesterday?
No, again.
Please describe why. Explain why.
What Dr. Curry went back to, which is this 98th percentile, which I told you in the manual. All you have to do is read the manual. It says specifically that we do not use the percentile ranks for this test. That indicates to me that, Dr. Curry does not know the psychometric properties of this test, and then she then is therefore not qualified to interpret it. That score, the one that's elevated, which she's talking about, that percentile rank, has a raw score. Amber's raw score is a 10. The cutoff score is a 15. She's nowhere near that level of exaggerated symptoms where I can't further look at that test. Secondly, there are 3 scales out of maybe there's about 20, a little more on the TSI that were elevated. Intrusive experiences, that's when thoughts and memories of the trauma come into your mind when you don't want them. Defensive avoidance, sort of behavioral ways that we try to push out those memories and not think about them. And then relational avoidance, a way of having difficulty in interpersonal relationships. Those are all trauma-based symptoms, and those were elevated on this test.
Thank you. Dr. Hughes, the MFAS, Dr. Curry addressed that as well and had criticisms for your interpretations. Do you agree with that?
No.
Please explain to the
So
jury.
the MFAST, as I told you last time, is a measure of malingering. It's the only measure of malingering that was done in this case. Dr. Curry did not independently administer a measure of malingering, and there are other ones that she could have done to augment her evaluation. And she kept saying something that MFAST is not for malingered PTSD. That's wrong on a couple levels. People who are going to malinger and feign don't only feign one diagnosis. They sometimes talk about all different symptoms that they have, and they exaggerate and they make themselves seem much worse than they are. So when you're doing an evaluation, you're giving a malingering measure to get a sense of how this person is responding to this evaluation. Now, what you do is you take those 3 tests that I talked to you about, the PAI, the TSI, and the MFAST, all with valid validity scales, you have greater confidence in your results. And that is in the literature, and that's literature that Dr. Curry cited in her report. That bolsters the methodology that I used. That in the study that had the PAI, the MFAST, and the TSI in the title of detecting feigned from bona fide PTSD.
Thank you. Now, Dr. Curry also talked about the danger assessment scale and suggested that you had inappropriately interpreted that. Do you agree?
That's also incorrect.
Please describe for the jury.
Which I told you last time, the danger assessment scale has statistically validated risk factors for serious or lethal domestic violence. Those risk factors exist whether we go forward, we're sitting with someone in an acute setting and assessing them right now, or if we look backward and we look retrospectively about what factors may have been present in a case that indicated severity. That instrument is used in what we call, there's called domestic fatality review boards. Those are boards after somebody has been killed, a homicide has occurred in a domestic situation. They look at these risk factors to see what was there and what could be done.
All right. Dr. Curry also criticized your administering of the CAPS-5. Do you agree with her criticisms?
I do not.
Will you please explain to the jury?
So the CAPS-5, as you all have heard multiple times, is a structured clinical interview in determining PTSD according to DSM-5 criteria. On this measure, Amber Heard scored in a moderate range. She did not over-exaggerate on this test. She could have said no, mild, moderate, severe, and extreme. All of hers were either 2s or 1s or 0s. Not above that. So she's scoring in the moderate range, which still has functional impairments. I mean, we don't want someone to be having moderate PTSD, but that's not an exaggerated profile or an exaggerated response style of someone who's answering an instrument.
Right. And the last of these Dr. Curry referred to was the PCL-5. Do you agree with her criticisms of your administration and interpretation of that?
No, so the PCL-5 is a checklist of symptoms of PTSD. It is, as she said, it is a face valid instrument. It means it's very clear about how you can endorse this. But what the person has to do is say, how disturbed am I by these symptoms? And when you have face valid measures with these other measures that have the built-in sort of ability scales, you're sort of controlling for that response bias error. You're controlling for that individual to sort of over-exaggerate. But then what you do with that test, because this is, we're not just administering them like robots, is you go and you do a clinical assessment. And that's what I did. I took what she wrote, what she endorsed on that test in January of 2021, and I did a clinical assessment of those symptoms to see if they meet criteria for PTSD. That is something we do clinically, and I do in my office all the time. And yes, she did meet PTSD from that in January 2021.
Thank you. Now, Dr. Curry said you misinterpreted her test results. Do you agree with that?
Yeah, I agree that I agree that I interpreted them, that she misinterpreted them.
Okay, and please explain.
Yes. So I said that before. My stance on the MMPI and how she interpreted it is, I believe, wrong, and I think
Objection, Your Honor.
All right.
That's the issue we just addressed.
All right.
I don't.
If you want to approach.
Now, Dr. Hughes, Dr. Curry also testified that a victim of PTSD has to effectively be prone and unable to function at all. Would you agree with that?
Objection misstates the evidence.
She said they couldn't hike, they couldn't move, they couldn't function in any way, shape, or form.
Objection.
Thank you.
No, that is not correct. That is often actually a myth and misconception about individuals who are struggling with PTSD or trauma-based disorders, and I'm often called to answer that and speak to that. People who are struggling with trauma and PTSD are very strong, courageous, resilient people, even though that they're struggling. They get up, they have to go to work and drop their kid off at school and go to the market, even though they're struggling with these symptoms. So I often talk about it as this sort of walking around with a 50-pound bag of flour on their backs, just sort of trying to get through the day, where sometimes that button's going to press play and the trauma's going to start activating in their head, and then they're going to be having to think about it and have startle and have physiological reactions until they can find a way to hit that pause and shut it off again. So they still have, impairments in other ways, but they go about their lives. They're not, totally debilitated. If you have someone in that high range, the highest score is an 80 on the CAPS, Ms. Hurd had a 28. If you have someone in the higher range, we have seen people who are, severely disabled because of it, but that's not the norm of people who have this moderate PTSD.
And did you find functional impairment with Amber?
Yes, I did.
Now, Dr. Curry also said that it is not within the scope of a psychologist to evaluate domestic violence. Do you agree with that?
Of course I don't agree with that. This is what I do for a living, day in, day out, for 25 years. We are specifically trained to understand the profound impact that trauma has on people's lives. That's what we do in the trauma division of the American Psychological Association. We disseminate that knowledge. And domestic violence is one of those profound traumas. Domestic violence is part of state licensing boards, that you can't get licensed in some states unless you take training on domestic violence. You can't renew your license unless you get training on domestic violence. So people who have, specialized training in this area, it is, beholden upon them to accurately assess for intimate partner violence and sexual violence. And it's more important to assess for this sort of scientific understanding of what domestic violence is. So you have to assess for the physical violence, the psychological violence, the surveillance, the economic, the emotional abuse, and the sexual violence. That is not gratuitous.
Objection.
That is understanding.
Narrative.
All right. Next question.
Okay. Now, Dr. Curry suggested that you made a determination just based on personal opinion and just on checklists and a couple of tests that you misinterpreted. Would you agree with that?
I vehemently disagree with that. As I stated to you, over 29 hours and 12 psychological tests and reviewing a slew of documents in this case, most importantly, therapy records and interviews, collateral interviews with therapists, using all that data, that is what a solid forensic methodological exam looks like. And then I made my conclusions based on my clinical education, knowledge, and training to come up with a professional expert opinion.
Okay. And just to remind, to make sure we're reminded here, you were qualified in this court, in this case, as an expert in forensic psychology, specifically in domestic violence and in no, I just lost it. And in violence, correct? Intimate, and in trauma, correct?
But I believe
Objection,
it-
Your Honor, misstates the record.
Yeah, if you want to ask the question again.
Yeah, I probably should do that. You were qualified, I gotta find my note. You were qualified as an expert in forensic psychology with a specialty in domestic violence and in trauma, correct?
Correct.
Okay, and that was in this case?
That's correct.
Okay. Now, do you still hold the same opinions you did that you gave the jury earlier?
Yes, I do.
And do you still hold them within a reasonable degree of psychological probability and certainty?
Yes, I do.
Thank you.
All right, cross-examination.
Yes, Your Honor, but can we approach quickly?
Sure.
Good morning, Dr. Hughes.
Good morning, Mr. Dennison.
The last time you were here, I believed that you testified that you had diagnosed Ms. Heard with PTSD before you gave the gold standard CAPS-5 test.
That's correct.
Right. And that diagnosis is actually reflected in the first of the disclosures you put forward in this case.
I believe the first disclosure was February 2021, and at that point I had done 11 psychological tests. That's correct.
Right. And your disclosure reads, Ms. Heard's responses on the PCL-5 support a DSM-5 diagnosis of post-traumatic stress disorder with an etiology of intimate partner violence she experienced by a former partner. You remember writing that?
That's correct.
Okay. You just testified that you need to read the manual, right?
Yes.
Okay. Can we put up 1311 as a demonstrative?
Any objection to
I don't know
1311?
what it is, Your Honor.
All right, if you want to
May
lay,
we approach?
you want to approach?
Tom,
Thank you.
I don't see this in my document either.
They're getting the right one up.
Yeah, we got it. Let's use 1312.
1312, okay. And that, any objection to that demonstrative?
No, Your Honor.
Okay, 1312 can be published to the jury.
Dr. Hughes, do you recognize what the National Center for PTSD is?
What it is?
Yeah.
Yes, I do.
And they publish the PTSD checklist for DSM-5,
That's correct.
that what we've been calling the PCL-5.
Correct.
All right. And do you, are you familiar with the document that's on your screen?
Yes.
All right. What is it?
It's the instruction manual to how to administer the PCL-5.
Okay. I'd like to move for the admission of 1312.
Any objection to 1312 coming into evidence? All right, 1312 in evidence.
All right. Can we go to the second page? Can we blow up the second paragraph on the right? That's the PCL-5 should not be used as a standalone diagnostic tool. When considering a diagnosis, the clinician will still need to use clinical interviewing skills and a recommended structured interview, e.g., the CAPS-5, to determine a diagnosis, correct? That's what the manual says.
Right, and this manual
Okay.
also says that this is a screening instrument, so when you do the clinical interviewing, you absolutely can determine diagnosis
So the
after
answer is
somebody
yes. The manual says you
still
that
need
the
to use
PCL-5
clinical interviewing skills, which I used.
Well, let me finish my question. The PCL-5 should not be used as a standalone diagnostic tool, and they recommend using the CAPS-5 to determine a diagnosis, correct?
It does say that, yes.
Yeah, and you made your diagnosis before you did the CAPS-5.
I made my diagnosis doing clinical interviewing and 11 other psychological tests that supported diagnosis of PTSD and symptomatology consistent with PTSD.
Okay. You said that we should read the manual. Would you also agree with me that we need to read the directions on these tests?
Sure.
Okay. Tom, can you pull up 1309 as a demonstrative?
Yes, sir. Thank you. Any objection of 1309 as a demonstrative?
May we approach?
Okay. And publish to the jury as demonstrative.
Doctor, do you recognize the demonstrative that's in front of you?
Yes, but I didn't put the red lines on that.
No, I did.
Yes, I know.
Okay. So this, what do you recognize this as?
I recognize that we previously discussed this, and I told you that I oriented Ms. Hurd to a different time frame because she was already out of the relationship.
Okay, maybe we should back it up a little. This is the CTS-2 that you administered as part of this battery of tests that you indicate you did in relationship to your diagnosis.
Right, this is the conflict tactic scale 2.
All right. And you'll agree with me that this test specifically asks, in front of every single question, how often did this happen in the past year?
Correct, and I
Right.
oriented
And
the
you
individual
know-
to not
I-
limit
it's
herself to the
correct.
last year to get an accurate assessment of the violence and abuse that she experienced in the relationship.
Objection, Your Honor, move to strike.
All right. I'll move strike the last part of the answer. Strike the last part of the answer. Thank you. Next question.
Yeah. And you know that at the time that you gave this test to Ms. Heard, she had been away from Mr. Depp for far longer than a year, correct?
Which is why I oriented her to a different
Yes or no,
time
ma'am?
frame in answering the questions.
Doctor, yes or no?
So, of course,
Okay, you knew she was gone for more than a year.
of course.
All right. Let's look at another one of these. You talked about the You talked about the danger assessment test.
That's correct.
All right.
What number is this? 13, plaintiff's 1310.
Thank you.
Any objection to 1310 as a
No, Your Honor.
demonstrative? Okay. You publish to the jury.
Dr. Hughes, this is a blank form, but this is the danger assessment test that you also gave to Ms. Heard, correct?
I didn't give it to her. I filled it out based on the data that was provided to me.
Oh, so you asked her the questions and then you filled it in.
It was somewhat collaborative.
Okay. Can we blow up the second full paragraph? It says, using the calendar, please mark the approximate dates during the past year when you were abused by your partner or ex-partner. You didn't use any calendar, did you?
I did not use a calendar because she was already out of the relationship. As I said, these are static risk factors, so they don't change. So I
But these
orient her to
exams-
the time of the relationship.
Ma'am, it's fair to say that this examination that you gave specifically indicates that you were supposed to look over the past year. And that's not the language?
No, that's one administration. People use this instrument for if you're in an acute situation in a relationship, trying to get a better assessment of the current behaviors. We can use it retrospectively, like I just stated, and in homicides and looking back about what are the serious risk factors that were in this relationship.
I didn't ask you about anything other than, don't the instructions limit this test to the previous year?
You can give this test not only on the previous
Nope, asking
year,
you about the instructions.
but I'm telling you how the test is administered in clinical practice and in forensic practice.
And opposing counsel can come up and ask questions about it. I'm asking you about the instructions. And the instructions say, look over the past year.
Yeah, on this, yes, that it says that.
And you had actual knowledge when you gave the test that Mr. Depp was gone way more than a year before this test.
That is correct.
Right. All right. Let's look at more instructions. Can we look at 1247, which is already in evidence? Dr. Hughes, you recognize this one too, right?
Yes,
All right. This is what everybody calls the CAPS 5.
correct.
All right, can we go to the first page? Let's blow up the instructions. Standard administration and scoring of the CAPS 5 are essential for producing reliable and valid scores and diagnostic decisions. Correct?
Correct.
And you know you have to do this in a standardized way because it is the first instruction, correct?
Correct.
Can we go to the next page? One more. Oh, wait. That's good. This is a page on scoring, and we talked about this last time.
Yes.
You score these tests by frequency, and intensity.
Correct.
And you'll remember that in every single instance that you were asked to fill in the blank about frequency, you failed to do so, correct?
That's not correct.
Oh, you filled in any blank on this form with respect to frequency?
I filled in the frequency on the side of the caps where I am actually scoring the caps.
No, I
Where
asked
it's
you whether
relevant.
you filled in a single blank on this form with respect to frequency. Is the answer to that yes or no?
I don't know what you mean, a single blank.
All right, let's page down. Let's keep going. All right, we'll stay at this page for a second. This is the very first box you're asked to fill in as to, I think, a fairly fundamental question, right? What happened?
We talked about this before, Mr. Dennison. I had 88 pages of notes of what happened. It would have been redundant to put it there.
You know that you are obligated to produce this test in a way that other people can meaningfully review them. Yes?
The people in this case who are meaningfully reviewing them have my 88 pages of notes.
Right. But you chose to put absolutely nothing in the box, the standardized box, that said what happened.
You don't have to put it in the box if you have it somewhere else. It's
Because
not a,
this
if
is
it's
not a
a
standardized test?
Well, if it's not a research instrument that is used for research, if you're using it for a clinical diagnostic purpose, no, you don't. If you have that data elsewhere.
Okay. Let's go another page or so. All right. Let's go another one. All right. Let's look at item 4B4. And I asked you whether you filled in the blank about frequency. And there's a blank in many of these items that asks number of times. You didn't fill a single one of them in, did you?
Right, because I filled them on the right side of the instrument where I am scoring it.
And that is the way that you believe that you followed the instructions of a standardized test.
Yes, correct.
No further questions.
All right, redirect.
Very briefly. You used the term static risk factor. What did you mean by that?
Static risk factors are risk factors that don't change. It's maybe if you smoke cigarettes, you may have a risk of lung cancer, right? That's a factor that doesn't change. You can look forward if someone's smoking, you can look past if someone's smoking. So these lethality risk factors are present whether you're evaluating them in the last year or 5 years ago.
And when you're trying to assess for trauma related to the interpersonal violence that we discussed, why is it important to get a time frame in which the relationship was in existence?
Well, you want to see the amount of trauma that the person experienced. The longer that they're in a relationship, you have more successive trauma. And one of the things that we know from the research is more trauma is not better. So the more successive traumas that you have, the greater likelihood that somebody's going to have psychological consequences and symptomatology as a result.
And therefore you need to get it within the relationship.
Objection leading.
And so how does that relate to needing to get the time frame in the relationship?
Well, you need to understand when you're trying to evaluate the impact of something, you have to understand what happened to the person. And that's sort of the core and the basis of trauma-informed care and of trauma diagnoses. You have to understand, the traumatic event and how it transpired and how it played out for that individual so that you can better assess for the symptomatology that's falling from it.
You said you had 88 pages of notes. What were in your 88? And without going into the specifics, can you just describe what was included in the 88 pages of notes?
In the 88 pages were many of the documented incidents of intimate partner
Objection, Your
violence.
Honor.
She's just describing it. That came up. He said you didn't fill those in the boxes. She said it was in my 88 pages. I'm just saying what was in your 88 pages. I'm not asking her to give each of the specific events. She can describe the summary of it.
Can we come up?
Okay.
What is the difference between clinical scoring and clinical evaluation and research evaluation with respect to the CAPS-5 and the other tests?
Action compound.
Sustained.
Your Honor, when it's compounded, it's because it might be confusing to the jury.
Sustained. Next question.
Okay. Can you explain to the jury what the difference is between clinical scoring and evaluation on a test and research?
Action, Your Honor, compound.
Overruled. Good.
Sure. So the PCL and the CAPS-5 are frequently used in research. And when they're used in research, that means the document stands alone. They don't have 88 pages of notes to help understand the background of the trauma and what the person has experienced. And why those boxes may be relevant in research is because, you know, back in the day when I was a research assistant, I had to input that into the computer. And then they would maybe look at some of that data for the research study. So that becomes very important in research.
All right. Thank you. I have no further questions.
All right. Thank you, Dr. Hughes. You can have a
Thank
seat in
you.
the courtroom or you're free to go, okay?
Thank you very much.
All right, ladies and gentlemen, let's go ahead and take our afternoon recess. Our morning recess. Let's take our 15-minute recess. Do not discuss the case with anybody and don't do any outside research, okay? All right, why don't we just come back at 11:05 then? All right, back 11:05.